Hi all, it's Tom Crawford here and Guy Taylor, and we're addressing the judgment that was passed down on the 14th of May. Now there's a lot of confusion with the judgment, and we hope to explain the ins and outs. This is part one of a two-part series, but I'll address one first thing that's been put out about two questions. The very first one was there was a possession order in 2006 that came about, which I explained in one of my videos or in a talk I did, that we wanted them to change the mortgage from the part and part back to the endowment, and the only way we could do it back then, because we didn't know the law, we simply refused to pay them any more money. Then they instigated possession proceedings. At that point we paid up. We got scared because they might take our home, and I think we were right, because they came afterwards and did exactly the same thing when I was ill and couldn't pay it. So that is the reason why that original possession order, we instigated that, but it didn't work. The second one was the £173 that they keep on going on about, that was paid into Sue's account, allegedly. Now, you haven't seen the documentation. I've already put it up on the internet, but they refer to a totally different account number. It hasn't been agreed in the court. The judge knows there's differences, and he remarked on it. So that's another load of nonsense. And for this here, because we both now agree that there was an endowment, they've backtracked. And I've held to that all these years. And this document here, from the second paragraph there, quite clearly states that it has been changed. It's been changed to a part and part, and it is no longer endowment. So they lied in court. And as I said before, this part here, the last one, where they sent us a gift saying, terribly sorry, we're not really criminals, we'll just send you some flowers, and that. I hope that's addressed that confusion. Now on to the judgment. And the judgment is the confusing part for people, because people are just reading the letters and the words on there as in English, but it's there to confuse you and us, and will also refer to the actual judgment of order, which was passed down after that. So I'll pass you over to Guy, and Guy will be more precise in the interpretation of a lot of this judgment, and then part two will be the judgment deciphered in each section. So
we'll firstly go into the skeleton argument for the appellant, and you can see that section 45 of the skeleton argument states this: A is therefore seeking an order setting aside the judgment and all the orders which arose out of it on the ground stated herein, relying upon in R.E. Barrel Enterprises 1973, Flower v. Lloyd 6 CHD 297, and pursuant to the Supreme Court Practice 1970, page 327, which states that if a judgment or an order has been obtained by fraud, or where evidence which could not possibly have been adduced at the original hearing is forthcoming, a fresh action will lie to impeach the original judgment. So that's on there. Now, in Tom's case, right, in the skeleton argument, there is also, in the county court judgment, there is also recognition of fraud, as mentioned before the start of section 75.
that's hardly unusual.
Hardly unusual. And here we go on to the arrears quantification in the judgment, where the judge clearly says, section 90, Mr. Crawford does not admit that the figure alleged to be outstanding on the total mortgage debt is correct, nor, I think, does he agree with the total arrears figure. Here, Mr. Crawford has a point. I can find nothing on the statement of account which show when capitalizations have occurred, although the total mortgage debt figures are more readily understandable. From January 2010, the format of statements of account changed, but it is not easy to see at any given time what the live account arrears are. At the time of commencement of the possession proceedings, arrears were said to total £1,802.90. That is not a figure which I could identify from the statement of account. When asked where it had come from, Miss Sandals for Bradford and Bingley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. I can't be plainer explaining what that's about, and we've said it many times because it's a key point of the entire judgment. If we go on to the judgment or order,
that's basically telling the barrister she lied.
Yes. And if we go on to the original judgment order and we look, we see that it's a general form. We see that it's not a seal, that's a stamp. And I'll go on later to explain, or I'll show now, that is a seal. And this is where the court documents start getting very shaky. Because if you give me, this is in another case, but they're both claims for possession of property. That's a claim for possession of property, and that's a claim form. You'll see that that one hasn't even got a seal on it, nothing at all. This one has a seal. Now when we turn over the page there, on this one, again this is another fraudulent instrument, you'll see where it's signed. You'll see the name Adam Penman. When you turn over on this one, which is a real one, you'll clearly see that where it's signed, it's been signed, not printed. Whereas on that one, they're both printed. So again, that's just showing you the level of what's going on inside these courts and how to recognise when they're a real document or when they're fraudulent. But going back to Tom's, so we've got over the issue of the seal. On 2 it says, permission to appeal is refused. Well, permission to appeal is refused. And we go to section 45 of the skeleton argument, which is the Flowers v. Lloyd case. And it states that if a judgment or order has been obtained by fraud, or evidence which could not possibly have been adduced at the original hearing is forthcoming, a fresh action will lie to impeach the original judgment. So that is clearly what has gone on in this case. So he couldn't make a stay on the warrant for possession, as there never was one presented in evidence. There was never a warrant in Tom's case presented as evidence. We've been asking for the warrant since day one. There's a notice of eviction, which is what he's basing it on, but not the warrant.
That's what he's executing.
That's exactly right, yeah. That's what it is. There is no warrant in this matter. If there is a warrant, show us it. That's what we've been asking. And but we know that there isn't, and we know that there's never even been a case through the courts themselves. I know that's not complicated, but it's an area I can break into once we've finished where we are on this. Yeah.
Okay, so that's the information that Guy has just put to you. Now I'll just do a bit more clarification on the actual order. Now the order is a follow-up of the judgment. The judgment is pronounced in court in front of witnesses. Sometimes not, but generally in front of witnesses. Then he passes down the order, which is the official sealing of the document, so then it becomes an actual proper court document. This is it here. Okay. Now I think maybe that'll be held for you so you can see. So going to the seal, when you compare it to the one that Guy just held up, that particular one, you can see the seal on this judgment isn't a seal, it just says County Court. And this one, it is a proper seal. Now the difference being is a seal is to state when the document was sealed and where. It should have had, as that one did, the date on the day that the judge pronounced judgment and where he pronounced judgment, and that has to be on the seal to make it an official document. So this isn't a court document, this is a forgery. Second is, when we talked about where it was sealed, well, he's got the county court at Nottingham. Everybody knows throughout this country that it was in the children's court, the family and children's court, and it was, he says it's a justice centre. So that's two right away. Sue and myself put in a claim to have the judgment set aside. Now the reason that I become a claimant is because I paid the money and put it into court, but God's Mark, in his wisdom, he's decided to reverse the roles. So in this, Bradford and Bingley become the claimants and we become the defendants.
Hopefully you're going to get your court fees back then.
Apparently he can change these things. Now if we go to the actual his judgment, where he says, upon hearing Mr. Crawford in person, and in brackets, assisted by his Mackenzie friend, Mr. Benicia. So, he's only listening to me now. He didn't listen before, because I'm telling him now the sky is tartan, because he can put it into an order. He should have said, upon hearing the evidence.
Upon reading.
Upon reading the evidence. And not only that, was I the only one in court? Was it barristers? Obviously not by this judge, because he only refers to us. He has to refer to all parties. That he didn't. So he's put the date on down the bottom and at the top, but that could have been printed at any time. The seal makes the document. So there are an awful lot of other things in this document, but just for general reference, it's worthless. So now it's back in court, so we can get a proper judgment with the truth. And Guy will go into more information.
Yeah, and of course Tom's next case is about the review and revise. So that's what that's about.
Yeah.
So it's not an appeal, but it's a review and revise. You've got headway for that today, haven't you?
Off this.
Off that. So we want clarification about exactly what's happened in their process and proceedings. And talking about process and proceedings, that's where a lot of this stuff falls foul, because there is no law without due process. No due process equals no law. So now this is due process of law is a constitutional guarantee, and it's guaranteed to us through Magna Carta section 39, and even in the civil procedure rules to a certain extent there's a guarantee that the rules will be adhered to under the overriding objective, which none of the CPR rules can do anything without the overriding objective being adhered to. So what's happened in these cases is they haven't been to court. You can find out if something's been to court by going and examining your court documents. And the reason I'm saying this is because law without process doesn't exist. It has to be due process, and due process has to be seen to be done.
Yeah.
As in a famous case, not only must justice be done, it must also be seen to be done. And of course we need to see the documents that they're claiming they've got, or they're claiming that has initiated the actions against Tom. And of course none of these have been forthcoming. So there's no evidence that there's ever been a court case against Tom. And I'll use the reference of what I was saying before. And we've shown you claim forms, and we've shown you seals. And in this particular case here, you'll see this gentleman, this is actually something they've trying to take his property off him for. And there is no seal in his court file, so there's been no process for this to go through the courts. So there's never been a court case. And when you turn over the page, you see that there's no signature. Now the same as in Tom's case. But this is just a printed one. I don't think there was any signature at all in your case.
No.
So there's no evidence that any of this stuff has gone through the court. And without that, without due process, they have no law. They haven't gone through that. It's fundamentally flawed. So, in all these areas and issues to do with accountancy, etc., you know, show us the ledger with the correct accountancy procedure, and including all the payments for the court's due process. Again, a judgment means nothing without jurisdiction. So the judge at that point had no jurisdiction to make anything for any appeal, because there was nothing to appeal, and that's quite simply why Tom was refused an appeal. An appeal had no merit because there was nothing to happen. There was nothing happened, and it's quite clear in the judgment itself. And you know. Right, so in Tom's case, not only did the court case never even start against him, because there was never a claim that went through the court, never any fee paid, never any court seal placed on a document to establish that it's gone through the court process. It gets worse, because every stage, when you analyse the process and procedure of it, it falls apart. And they've got as far as going to the notice of eviction. And again, people tend to think these are court documents. They're not, they're just forms printed out. Yep. And this notice of eviction is as far as we've seen. Well, now, that's supposed to be attached to the warrant.
That's right.
Now, the warrant doesn't exist. Well, it's like, they talk about it, it's like the Golden Fleece or something, you know what I mean?
It's supposed to have all an affidavit attached to it. It's supposed to have all the information of monies that's owed. It's have to have every bit of the process attached to that warrant.
And none of it applies. And as far as I'm concerned, from the very beginning, there's no need to go any further, because when you take a claim form, you get a claim form offline or whatever, you take it into court, and you go into the court with it, and you pay your fee, and it gets sealed. That means it's been processed by the court, as in the copy we showed you. So when this gentleman went down and put his court documents in, they gave him the seal, he paid a fee, which he can produce a receipt for, and he signed the document. As simple as that. Now, in Tom's case, none of that has happened. So we've got no evidence there's ever been a court case. From that point, we can argue about the later procedures that went on, and whether or not they actually happened either, because none of them are signed or sealed or anything, which they should be. They must be, to be compliant with their own rules.
The judge knows this as well.
The judge knows this, and so really and truthfully, we're in a situation where
he's been sitting in fraud, basically.
He's been sitting in fraud, and if they're going to come with if they're going to come to your house at any time, show us the documents. That's all we ask. People don't hand the keys of their homes over.
Don't do it
without making sure that the correct procedure to the prescribed form has been adhered to. And unfortunately, people have been doing that, and everybody's been getting robbed. Everybody shouldn't be examining the process procedures. And if you were wealthy enough to afford a lawyer and pay him £1 million to attack Tom's case, the first thing they do is attack the process and procedure. They wouldn't go into the merits of the case and all that. It would take hours, and they're not interested. They know where the faults lie, and the faults lie in the process and procedure. And a lawyer will probably take a lot of heat off the Law Society, because as an officer of the court, he's not supposed to undermine the court process. But unfortunately, the court process is running a criminal enterprise, for want of a better term, and a lot of these people know it. They're either criminals or cowards. And to prove the point, just show us the documents, show us a claim form with a seal on it and the fees paid, right? Show us the warrant. What is it? Why this mythical beast called a warrant?
So basically, we've covered the the two major points that people wanted to know, which was permission to appeal is refused. You can't refuse. Well, you can't do anything unless it happened. You can't stop something unless it started. So there was no procedure.
Yeah.
And the execution of the warrant doesn't exist. What they're actually talking about is the execution of the notice of eviction.
I'll tell you what to do.
Nothing else.
I'll tell you what people can do, Tom. Appeal something that hasn't happened. Go down the court and fill out all the forms to appeal something that hasn't happened in your life, and see if you get granted the appeal.
Yeah, exactly.
See if they grant it.
So nothing happened. There was no warrant, and the only thing he could actually do is lift the stay of execution. And it isn't of the warrant, it's of the notice of eviction. And that will be broken down to in part two, in the documents itself.
And what we've been flicking in and out for is because this stuff's going on an industrial scale throughout the United Kingdom. Tom's case is highlighting this, and that's why, you know, I know there hasn't even been a case against Tom. There's no documents to support that there any merits that there's been a case against him, and none of them any documents are not to the prescribed form and haven't been through a court. But that's another issue, because people are talking about appeals that have been for things that haven't happened anyway. So we flick in and out, but it's all very obvious when you boil down to the nitty-gritty, and you just want the evidence. You want the evidence.
The way I explain it sometimes, it may be correct or wrong, it'd be like standing in front of a big red double-decker bus and complaining to the conductor that he's missed the bus that's started, and yet quite obviously it hasn't left the base. That's the same as ours. You cannot appeal something that hasn't taken place. So let's hope that's cleared up that one. It may be a bit confusing to understand the stay of execution, but that will be addressed in the actual part 2 in the documents. But we're absolutely 99.9, because we are dealing with criminals here, that Sue and myself's home is safe. And if this stops a lot of the chit-chat and the infighting that it's caused, and it's been instigated by certain individuals, but they've got their reasons. I'll leave it to them, but I hope this clarifies things for you all.
Yep. Right, as far as the claim form goes, which you presented to the court.
That's right. All filled out very nicely, very eloquently, and very precise.
The judge didn't make any reference to it?
No, nothing.
None at all. So what would you assume the reason for that was?
He couldn't address the facts. He only could address the hearsay of the barrister.
Of the barrister for the bank.
Yeah.
Right. And of course the actual figures, none of them added up, as we know, as the judge said in his judgment. So he couldn't actually be dealing with any factual figures even.
Nope.
And we didn't have a competent witness called at any stage in the game.
No, except myself.
Except yourself. In which he claims that you're the only thing he heard in the court.
That's probably correct then.
Yeah, because anything he saw was in fact false. So, when we go back to the file, what would we expect to see? Someone's originally made a claim against you, and then there's been various proceedings where you've made applications and they've made applications. So inside the file we'd expect to see proof of fees paid, requests for applications for whatever it is, a warrant, or
judgments.
Judgments.
Just a simple thing like a judgment would be nice.
And we'd expect to see those documents complete, chronologically correct.
That's
so
right.
Order, and if everything was running right and it was running through a court, we would.
Yeah.
But when we go to the court, we find
They're not there.
they're not there.
No.
So what evidence is there that the law must be seen to be done? So what can we see to prove there's ever been a court case against you?
There is absolutely nothing.
Absolutely nothing.
Except I physically end up sitting on a bench in court. Nothing. And it is totally unlawful. Not just illegal, it's unlawful what they do.
Yeah. So judges can't just wake up in the morning and start going around and giving out orders without them being supported by
The proper
documentation, seals and stamps and requests and payments, etc.
Yeah.
And if there's been any breach in this, that's what they used to call technicalities. And if you're a very rich person, how did he get out of that? How did he possibly get out of that case? On a technicality. And what
murder cases as well.
Murder cases as well.
O.J. Simpson, prime example.
Yeah. Again, I know of a murder case with a guy I was actually, I knew of, and evidence. He went in the house, done what he did. But absolutely.
Here's a thing to address then, because people ask, why did Bradford and Bingley solicitors, Walker Morris, drop their charges towards the case? Now we're looking at 30,000 minimum for that day, and to come back to court to hear the actual judgment, another 10,000. We're looking at 40,000, a payday that they passed up Why would you suggest that they did that?
Well, I'd suggest a possibility of a thing called taxation.
Exactly.
Because all relevant evidence that all costs must be taxed to be liquidated hasn't been produced.
No.
So they'd have to produce evidence of all the processes and procedures which we're already asking for and prove that there's been taxation through the taxing team of the court.
That's right.
That could be a problem.
We could get access to that, and then they're in big poo-poo.
Yeah. And so we're again into another area of we can't suggest it yet, but we can infer it because we haven't seen anything to the contrary.
That's right.
So this is what's been going on with these characters, and this is why they didn't turn up in court. If they'd had a victory, surely you'd have thought they'd have turned up for the victory.
And gloat.
And gloat or whatever, but they didn't. They didn't turn up because they didn't win.
That's plain and simple.
Plain and simple.
And they're scared of the taxman as well now,
Well, yes.
because they could end up in serious trouble with that.
Taxing team, where are you? Right, as far as the claim form goes, which you presented to the court,
That's right. All filled out very nicely, very eloquently, and very precise.
the judge didn't make any reference to it.
No, nothing.
None at all. So what would you assume the reason for that was?
He couldn't address the facts. He only could address the hearsay of the barrister.
Of the barrister for the bank.
Yeah.
Right. And of course the actual figures, none of them added up, as we know, as the judge said in his judgment. So he couldn't actually be dealing with any factual figures even.
Nope.
And we didn't have a competent witness called at any stage in the game.
No, except myself.
Except yourself. In which he claims that you're the only thing he heard in the court.
That's probably correct then.
Yeah, because anything he saw was in fact false. So, when we go back to the file, what would we expect to see? Someone's originally made a claim against you, and then there's been various proceedings where you've made applications and they've made applications. So inside the file we'd expect to see proof of fees paid,
Yep.
requests for applications for whatever it is, a warrant or
Judgments.
judgments.
Just a simple thing like a judgment would be nice.
And we'd expect to see those documents complete, chronologically correct.
That's
so
right.
in order, and if everything was running right and it was running through a court, we would.
Yeah.
But when we go to the court, we find
They're not there.
they're not there.
No.
So what evidence is there that the law must be seen to be done? So what can we see to prove there's ever been a court case against you?
There was absolutely nothing.
Absolutely nothing.
Except I physically end up sitting on a bench in court with nothing. And it is totally unlawful. Not just illegal, it's unlawful what to do.
Yeah. So judges can't just wake up in the morning and start going around and giving out orders without them being supported by
The proper
documentation, seals and stamps and requests and payments, etc.
Yeah.
And if there's been any breach in this, that's what they used to call technicalities. And if you're a very rich person, how did he get out of that? How did he possibly get out of that case? On a technicality. And
Murder cases as well.
Murder cases as well.
O.J. Simpson, prime example.
Yeah. Again, I know of a murder case with a guy I was actually, I knew of, and evidence he went in the house, done what he did. But absolutely.
Here's a thing to address then, because people ask, why did Bradford and Bingley solicitors, Walker Morris, drop their charges towards the case? Now we're looking at 30,000 minimum for that day, and to come back to court to hear the actual judgment, another 10,000. We're looking at 40,000, a payday that they passed up. Why would you suggest that they did that?
Well, I'd suggest a possibility of a thing called taxation.
Exactly.
Because all relevant evidence that all costs must be taxed to be liquidated hasn't been produced.
No.
So they'd have to produce evidence of all the processes and procedures which we're already asking for and prove that there's been taxation through the taxing team of the court.
That's right.
That could be a problem.
Because we could get access to that, and then they're in
Then they're
big
in
poo-poo.
Yeah. So we're again into another area of, we can't suggest it yet, but we can infer it because we haven't seen anything to the contrary.
That's right.
So this is what's been going on with these characters, and this is why they didn't turn up in court. If they'd had a victory, surely you'd have thought they'd have turned up for the victory.
And gloats.
And gloats, or whatever, but they didn't. They didn't turn up because they didn't win.
That's plain and simple.
Plain and simple.
And they're scared of the taxman as well now,
Well, yes.
because they could end up in serious trouble with that.
Taxing team, where are you?
Okay, what we'll do then is we'll go to the pub and we'll do this again and compare the two.
Yeah, I'll tell you what, because things become clearer after a lot of drinking, don't they?
Oh, much clearer.
And we might do a bit of dancing, Mark.
If we do, I'll make sure to put that on the YouTube
Oh,
channel.
yeah. But
Put it on after this.
Okay, that's an idea.
Debt Free TV, in association with GetOutOfDebtFree.org.